The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Everyone, please be seated. We are here today for the final case in the morning, Jason Carter versus State of Iowa and others. Are the parties ready to proceed? It's my understanding Mr. Olson will be arguing? Yes, Your Honor. Thank you. You may begin.
May it please the court, counsel. There are lines that exist which law enforcement may not cross. These lines aren't drawn in sand. They're not drawn with chalk. They're etched into the foundations of this state. 1857, our most recent Constitution. Those lines set the metes and bounds of what law enforcement may and may not do to Iowa citizens. And just because Jason Carter was not beaten with a billy club does not mean that law enforcement can do whatever they want when investigating a crime. And actually, the actions of Agent Ludwig here are far worse than a beating. Bruises heal. But a family was torn apart by purposeful, reckless actions of the lead investigator when investigating a crime. Leads were ignored, confessions were swept under the rug. Actual video evidence was just not paid attention to. And instead, Agent Ludwig doggedly pursued Jason Carter, creating a case against him. I'm sorry. Yes,
We're getting there. I just want to be clear on which counts are still live on appeal.
Your Honor, it is counts 1, 3, and 4. There are, it's an unreasonable search and seizure under Article 1, Section 8, and then there are two separate Article 1, Section 9 due process, substantive due process claims.
Any other question? Both of your counts related to due process are substantive, not procedural, correct? One of the more consequential and alarming actions that Agent Ludwig did, which relates to count 1, is the swearing out of an arrest warrant, knowing that there were omissions that were material and relevant, and including mere conclusions, removing from that magistrate the ability to actually weigh the evidence and make a determination of whether or not probable cause exists. On that point, you say in your petition that the judge that swore out the warrant is the same judge that that tried the civil case. Am I right about that? That you say that in your petition? And
That's correct.
And does that fact weigh into this analysis at all with respect to the probable cause?
That fact is important to know in the case. However, as this court's aware, when a magistrate reviews an arrest warrant or a search warrant or any affidavit regarding a warrant, they only look at the four corners of that document. And if there are other factors or information considered by that judge, they're supposed to provide that information into the record with that warrant and with that application. The fact that none...
The judge found that to be deficient, they would generally have some kind of colloquy maybe with the affiant then?
The judge could have a colloquy with the affiant, yes. And again, that would either be on the record or there would be written notes from the judge. None of those were provided below. So,
on the search and seizure claim, what specific facts are you alleging were unconstitutional? Is it swearing out the warrant? Is it executing the warrant? Is it both?
Justice McDonald, the unconstitutional actions started far before the warrant actually was sworn out. It was the reckless collection of evidence and the failure to do an adequate investigation. However, specific to the affidavit, first of all, there's...
the failure to investigate implicate search and seizure under Article 1, Section 8. So what is the unlawful search or seizure that's being challenged?
Search or seizure is providing a deficient affidavit, both that contain mere conclusions instead of the actual facts that allegedly supported those conclusions, but also putting statements in there that were knowingly false, that Agent Ludwig had access to information to show that the statements within that warrant affidavit were false, and yet pursuing it still. So it's the action of filling out the affidavit, swearing to the court that this is true when it was knowingly not.
Counsel, the state argues that your constitutional claims are really just common law claims, abuse of process, malicious prosecution, dressed up as a constitutional claim. Respond to that, if you would.
Thank you, Justice McDermott. The state would like that, but case law, recent case law from this court, as well as from past iterations of this court, say that it's not the case. If you look at the Trobal v. Sondag case, the Smith v. Iowa State University, simply because certain of the actions of the state agent here could be compared to accepted claims under Chapter 669 does not mean that these claims fall under Chapter 669.
Arguing that if they were the functional equivalent of the claims within the exceptions in 614.4, then would they fall under those exceptions?
Constitutional claims wouldn't fall under the exceptions. The state is throwing a red herring trying to say that these are functional equivalents, but since they're constitutional claims, and since the actions we pled are far beyond a typical abuse of process claim or a typical false arrest claim, I mean, this isn't a situation where Agent Ludwig followed the wrong black Toyota Camry and arrested the wrong person, and that person was litigious and sued. This wasn't an honest mistake.
You were talking about some of our cases. How does our recent case of Wagner play into the analysis of whether or not functional equivalence even matters when there's a constitutional claim?
Justice Oxley, our position is that when we have a constitutional tort, such as here, such as obviously Wagner or Baldwin or these other cases, we look at whether or not the all due care immunity applies. And that's the question on
Going to qualified immunity there, which is a little bit different, but I do have a question on that. Which counts do the all due care standard apply to? Have we specified where what the level of qualified immunity is for sections, all of your claims under 8 and 9, or just under some of your claims?
all due care immunity would apply to Claim 1. That's under Article 1, Section 8. That's, if my recollection is correct, Baldwin, I believe, specifies that all due care applies to Article 1, Section 8. Baldwin does not address claims under Article 1, Section 9. Obviously, there's other case law, but since it's a substantive due process claims, there are other controls and pleading requirements that I don't believe all due care actually applies to that. However, if this court does determine that all due care immunity should apply to Article 1, Section 9 claims as well, our pleadings have far surpassed that at this stage. So we've pled egregious conduct that is conscience shocking. So even if there is some sort of all due care immunity that perhaps plays into a conscience shocking pleading standard, we've met that. But
Instruction look like if you were to try an Article 1, Section 8 claim?
Your Honor, I appreciate you giving me a second to think about that. I hadn't contemplated that question. I think a jury instruction would ask whether or not I'm not sure how to answer that question. And I think that
Problem with Godfrey? I mean, we have this cause of action. Nobody's quite sure what it means, if we're all being candid. Nobody knows what a jury instruction looks like, and how you would charge it. So why not just have common law causes of action and say state actors can't be immune and resolve it that way?
I think there does need to be some control, and the legislature needs to have some say over what torts can and can't be brought. That's obviously the purpose of Chapter 669. But as far as the Godfrey claims, Your Honor, I think that the federal contemporary, a Bivens action, and jury instructions under Bivens claims could be instructional. This court has looked many times to federal precedent when perhaps we want a little more light on the path moving forward. So that would be one answer to that. And
Itself, I mean, and they've recently acknowledged this, that Bivens is dead. I mean, they've applied it twice post-Bivens. They've cabined it into 3 very discrete categories of claims. And they made pretty clear recently that they are not going to extend it. People shouldn't bring Bivens claims. And if we're following that precedent, it would indicate that Godfrey shouldn't be a claim and that we should cabinet to Godfrey and just be done with it. So should we follow the federal precedent on Bivens?
we should follow the federal precedent when it looks at jury instructions. But here, this court, and as far as the rights of Iowans go, we have exceeded the federal requirements and protections for our citizens for decades and centuries. And I think that that is the precedent that we should continue to follow to ensure that the rights of Iowans are protected, and using not the federal Constitution as the, using that as the floor and growing from there.
In Godfrey, in the concurrence that Chief Justice Katie wrote, he talked about how a Godfrey claim would only arise if the common law didn't provide for any sort of remedy. And where I'm struggling here is, what is the deficiency in the common law claims that would require us to look to a new constitutional claim, a Godfrey-type claim, in this case? What is it that makes the common law remedies lacking?
Your Honor, I would, Justice McDermott, I would say, first of all, that these aren't new claims. We've recognized substantive due process claims under the Iowa Constitution in the past. This court has, and this court has recognized for over a century constitutional claims based on unreasonable searches and seizures. So this is recognizing past precedent and allowing this claim to proceed, not opening the door to a new claim. As far as the common law versus the constitutional, I think that if we were to just open the door to all common law claims, the legislature maybe should have a say in that regarding just regular common law claims. But the constitutional claims, those claims that are written in and ascribed by the individuals who actually wrote the Constitution in 1857, those are limited to egregious behavior such as we have pled here. The typical torts, the common law that you've discussed, I think those are addressed under Chapter 669. We're not asking for an expansion of that. We're not even asking for an exception to 669 because we're not here talking about that today. Our constitutional claims are outside of Chapter 669. And part of the reason, and I think, Justice Oxley, your question about which claims are still here and before this court is the Chapter 669 claims that were brought below, those weren't appealed. And they weren't appealed because we wanted to discuss the constitutional claims and we wanted to focus this argument on the most powerful claims that we have.
Well, so you're talking about some of the immunities and following federal precedent. Qualified immunity, we've said, and the federal courts have said, should be decided early in the case. Why is that not the case here?
The federal courts have said that. And this court has, pardon me, has also said that they should be decided early, but the all due care immunity is to be pled and proven. Pled and proven. The state has not entered a single pleading in this case, has not entered a single fact. They filed a pre-answer motion to dismiss. And whether or not immunities might apply at a later time, that's a question for summary judgment. And here, we're here on a motion to dismiss. Every single one of the facts.
Federal court, they're dismissed on motions to dismiss frequently in federal court.
And while federal court could be instructive, it's only persuasive here. And especially when, I think it was 4 years ago, perhaps 3, in the one of the most recent Baldwin cases, the pled and proven standard for our constitutional all due care immunity. That's the standard that we're asking this court to continue to apply when it comes to constitutional torts raised under Article 1, Section 8 and 9. I see I only have about 20 seconds left. I'm happy to answer questions, or if I could have just a brief moment to close.
As the appellant, so we'll have you take a seat, and we'll now listen to you, Ms. Register.
May it please the court, counsel. Good morning. My name is Tessa Register, and I'm here on behalf of the state of Iowa and Agent Mark Ludwig. I think I'm going to start about what Godfrey means, what do we do with it, what do we know? I think in this case, there are 2 principles I really want to focus on. First, what we know is the standards, defenses, principles that apply to a Godfrey claim will change depending on who the defendant is and what the claim is. We know that if the defendant is a municipality, we're going to apply the Municipal Tort Claims Act wholesale because Baldwin II found that was the legislature's intent. And we know from Wagner, if the defendant is the state, we're going to do a piecemeal approach. The procedural aspects of the Iowa Tort Claims Act will apply. The substantive will apply on a case-by-case basis. For example, the excessive force case, excessive force claim, punitive damages will apply. It made clear to state that's not or punitive damages are prohibited. That's not necessarily true for other claims.
That with respect to state defendants, that the functional equivalent analysis is not relevant post-Wagner. So, okay, well, here's my specific question then. So footnote 6 of Wagner says that Godfrey effectively abrogated the exceptions from the waiver of sovereign immunity, and that, so Wagner was an Article 1, Section 8 claim, if I recall correctly, and the court said that could proceed because Godfrey requires the waiver of sovereign immunity, even though it's functionally equivalent to an assault, battery, et cetera. So why is that interpretation of Wagner wrong?
There. If that's the right interpretation of Wagner, then Wagner got Godfrey wrong. Because in Godfrey, it was quite clear that they didn't reach any issue about 669 Iowa Tort Claims Act, sovereign immunity. That's explicit in the text. And so I think to the extent Wagner found that to be an implicit holding of Godfrey, I think that was a misreading of Godfrey.
Your claim proceed then?
Getting there. So when we're going through, I think we're going claim by claim. And so I think it found that when we're talking about absolute immunities and things like sovereign immunity, which is an absolute immunity, we have those in code and in common law, and they're justified by the availability of other remedies. We don't let you sue judges because if a judge entered an erroneous judgment, you can appeal. That appeal is your remedy. We don't let you sue prosecutors for initiating charges because you can challenge that. Yeah.
You're talking about absolute immunity, not sovereign immunity.
Type of absolute immunity. No, yeah, I'm getting there. Yeah. Mm-hmm.
Section 8 claim against a state official, and the state has not waived it. How did Wagner proceed?
Wagner proceeded because the justifications for that absolute immunity were lacking. The reason we have the absolute immunities for false arrest and false imprisonment are because there are procedural remedies available. You get a preliminary hearing, a suppression hearing, a day in court, Brady protections. But when an officer kills you, you don't get any of that. And so the justifications for that absolute immunity are lacking. When you're shot and killed by the police, you don't have a preliminary hearing to challenge that decision. You don't have a suppression hearing to punish the government, and you don't have your day in court. So,
Different than sovereign immunity. Sovereign immunity is a decision by the government that in certain circumstances it's going to allow itself or its officials to be sued. I'm not sure what all those other things have to do with that. I mean, either the state decides it wants to be sued or not, period.
for that decision, but I think Wagner says that this court can disregard some of those decisions in service of the Constitution. And I'm saying a plausible reading of Wagner is that the reason we got there is because the justifications for that waiver were absent, and therefore that's a reason to not follow the legislature's path. But here, I believe the justifications for these immunities are present, which is a reason to follow the legislature's path. And another key takeaway.
Immunities, so you're going to immunities, right?
Forward, which is a substantive provision which I think should apply to these particular tort claims. And I think they should apply because all the justifications for that absolute immunity are present. He was given a preliminary hearing. He was given a suppression hearing. He was given his day of court. He did come to court with that high burden of proof. And so those justifications that were deprived of the person in Wagner are present here. And I think that's a material difference between 669 for why we wouldn't apply the substantive provision in Wagner, but we would apply it here.
Police officer assaults somebody, doesn't kill them. Does sovereign immunity apply?
I think under Wagner, no, because the basis for that assault exception the justification wouldn't be present. You don't have those procedural remedies. And so something Godfrey talked a lot about was their concern was the person for whom it's damages or it's nothing. That was a main concern, right? If your house is ransacked but you're never charged, you don't get those procedural remedies. Someone who's assaulted, you don't get those procedural remedies. So that would be a situation where the justification for the immunity is absent, and this court in creating a cause of action would then imply a damages remedy to make sure there is a remedy. But in situations where we do have the procedural remedies and we do have the procedural safeguards and they were used, that's a much lower justification for this court to step in and imply its own damages, because he was given all of the remedies that this Constitution and the legislature require.
How do we decide that at motion to dismiss?
That he was given, this is not a procedural due process challenge, he was given all of the criminal procedures available and required by the Constitution. He is not alleged he was deprived of any of those.
To the criminal proceeding, he's also bringing substantive due process claims related to the civil proceeding.
The civil proceeding was appealed, which is the remedy for the civil process. If he
To the defendant, and it was or he was the defendant, but in the civil suit, it was between Jason Carter and his father. This is a different claim against a different defendant related to that defendant's involvement in those cases. So I'm not sure, and even, I mean, the federal claims that were brought in this case, so Mr. Carter has brought claims in federal court, right? I'm sorry, not the federal claims, but in federal court, and the district court dismissed him on Rooker-Feldman, but the Eighth Circuit reversed that and said that the civil trial does not prohibit the separate claims against the investigator in the state.
conflating a couple things. So it's not a false arrest, false imprisonment exception under 694 that bars count 3. It's the abusive process and malicious prosecution that bars count 3. Those are separate. That is separate exemption. But again, what is your remedy when someone testifies against you injuriously? Your remedy is to cross-examine them. And if you feel they participated in a judgment and that judgment was wrong, your remedy is to appeal. And so the justifications for the abusive process and malicious prosecution exemptions are fully justified here and are present here.
What about his attorney fees for the criminal case? I think that's one of the things that he's seeking here. How does he get those back?
Any constitutional right to obtain attorney's fees.
I think he's claiming those as damages, right, for the misconduct of Officer Ludwig.
I don't think we can assign the decision to charge him and continue the prosecution to Agent Ludwig. I think that was a prosecutor. I think Agent Ludwig's liability under the Constitution is twofold. It's arresting with good cause, in this case, which was a good warrant, and it was performing a sufficient investigation prior to arrest. That's the substantive due process component. Those are Agent Ludwig's liabilities here. Decisions to prosecute and continue through prosecution through trial are assigned to the prosecutor, and I don't think that's fairly assigned to Ludwig in this case.
The warrant application then. You said it was a good warrant application, but we're on motion to dismiss. And if you look at the way it's been pled, he included things, the investigator included things that he knew were false, and he excluded things that he knew were exculpatory, taking the pleading on its face. And so how can we say, I think in Vincus, we said the motion to dismiss with respect to police officers, because the way it was pled, couldn't be dismissed at motion to dismiss, and we reversed and sent that back.
Not sure if Incus was based on a warrant or not, and I apologize, I can't remember. But here, I think the way it's pled actually does support that the warrant was good. That's a legal conclusion, right? You don't just get to allege that it was recklessly intentionally included. Those are legal conclusions not entitled to any weight. And I think looking at the petition, what we know is that the law enforcement was aware of all the civil testimony that came in, and that's the Carter case. So that's a good jumping off point. And so looking at what law enforcement reasonably could have known at the time, taking all of their petitions as true, is that a reasonable person could have looked at that objective crime scene evidence and found a burglary was staged. And I think Jason did tell law enforcement that he didn't know about the gun safe, and then his prints were found on the gun safe. Discovery is not going to disprove that. And so when we know we're going to be right back here.
Civil case, or are you getting that from their petition?
Petition. There's nothing in the petition undermining the burglary, and in the petition, there's nothing undermining the fact that he did tell law enforcement that he had no knowledge of the gun safe and never touched it, didn't know their parents had it, and then his fingerprints were found on. Nothing in the petition undermines that.
It says anything about him claiming that he didn't know that there was, is that in the petition?
Carter civil case.
My point. What gives us the authority to look at what was going on in the Carter civil case if we're on motion to dismiss, notice pleading standard in this separate case against a different individual?
Well, I think it's a unique case because we know what law enforcement had in front of it at the time it applied for that warrant. That's unique. And we have that testimony in front of you. But I think, again, I don't know that there's anything you have to take as true in that petition that contradicts the warrant. And I think then, but let's say, I think that's where all due care comes in, right? So, and I think the court's recent Bracey decision is really instructive. So Jason takes this divide and conquer approach to the warrant, which is not how we review it. And as Bracey noted, if a judge wants more information before making a probable cause finding, they can ask for it. And when that doesn't happen and the officer believes I have probable cause and the judge signs off, that's all we ask officers to do. It's not their job to second guess that determination. And so even if you find that the judge shouldn't have considered certain information, or even if you find it's possible, that's not the question. The question is whether Officer Ludwig, whether the arrest was supported by probable cause or good faith belief in probable cause. I think the answer here is yes, and I think the petition shows that. And I did want to respond to Justice McDonald's question about the warrant and what this suit is. If Agent Ludwig had drafted a warrant and had included recklessly false information he knew to be false and then put it in a drawer, the Constitution would not be violated. If he had presented it to the judge and the judge said no and that was the end of it, the Constitution would not be violated. Article 1, Section 8 search and seizure only comes in when the person is seized in the absence of good cause without the valid warrant. And so that's when the constitutional violation comes into play, which is why this is count 1 is a false arrest claim. I did want to make a couple final points here. So Jason cites 3 cases in his brief discussing the degree of investigation needed before arresting the suspect. And I really just, yeah.
Right? You said that's why this is a false arrest claim. Count 1. Why does that matter legally?
Because I believe the 669 and 14.4 sections should substantively apply to claims like Jason's where it's not damages or nothing, and because they should apply, the functional equivalent analysis comes in, and it is the functional equivalent of a false arrest claim.
Wagner is what?
1, if Wagner believes Godfrey requires that we exclude all of those, then Wagner misread Godfrey. And 2, if it didn't misread Godfrey, then we can distinguish that between, again, with the principle if we want to uphold the legislature's intent as much as possible, then there's a reason to uphold the legislature's intent here because the bases for the immunities and the justifications for that immunity were fully satisfied. This is not someone who's in a position of damages or nothing. He did get all of the remedies that are available, which justify that.
Arrested. What's his remedy is adequate to compensate him?
I think, yeah. Sure. I I think it's all of the procedural safeguards we give to maintain the rights of arrestees and deter officer misconduct. Things like a preliminary hearing, things like a suppression hearing, things like Brady, things like that extremely high burden of proof. And I think the US Supreme Court actually put a nice point on this in Egbert in the 2022 post-briefing, Egbert case, where they declined to imply a Bivens cause of action because an adequate remedy existed within the regulatory grievance process of Border Patrol. That is a non-damages remedy that was determined to be adequate, such that it would preclude a Bivens claim. And I think this is another way to harmonize Godfrey and Bivens in this case, is taking a similar approach, that a non-damages remedy can be adequate for constitutional torts as long as it provides deterrence and effective remedy. And here Jason did get those procedural remedies. All of the justifications were satisfied, like in Egbert.
You be allowed to pursue a common law claim. I mean, the false arrest claim has such a long historical tradition. It's always been recognized. And it seems to me kind of a legal fiction to say, well, 669 prevents false arrest claims, so instead we're going to create a constitutional tort that's the equivalent of false arrest. Why don't we just say Article 1, Section 8 prohibits the immunities for these kinds of claims arising out of search and seizure? I mean, it has to mean that, right?
The order of operations. So we're going to imply the cause of action when two things are present. The language is self-executing and there's no other cause of action in code. Here, 804 does not imply a cause of action. So, and we didn't challenge that. We assumed for the purposes of this motion that those two things were satisfied and the cause of action was implied. But once we do that, that's the end of the adequacy of the remedy inquiry. The adequacy of the remedy comes in when we're implying the claim, but once we do that, it's now a tort claim, and we can talk about things like defenses and procedures and how it goes forth. And there are plenty of defenses that block tort claims. Statute of limitations block tort claims. Exhaustion procedures block tort claims. That doesn't make them unconstitutional. It doesn't mean, even if it means they don't get to recover and therefore deprived of an adequate remedy, that puts, I think, the cart before the horse a little bit. I see that I'm out of time. For those reasons, you should affirm the district court. Thank you.
Thank you, Your Honors. Justice McDonald, on the line of questioning that you had, I do think that the Constitution in some ways trumps Chapter 669. I think that they can be read in harmony where they're egregious constitutional claims that are completely outside of Chapter 669. And I think that jurisprudence from this court supports that, because we've had claims regarding unreasonable search and seizures long before Chapter 669 was enacted. So that's self-executing. Justice McDermott, regarding your prior question on common law torts, could a common law tort be brought? Yes, absolutely. I don't know that it necessarily has to be a constitutional tort. The concern, though, is the adequacy of the remedy here, and that's part of the reason we asserted a constitutional tort as opposed to a common law tort. There's a concern about what is an adequate remedy if we don't say Jason's constitutional rights were violated, because this was a state actor. If this was just someone who came in and lied to Jason's family to split him and his father up and hid things that were going to help him, you might be able to bring an action against a private party.
Damages? Are there punitive damages that wouldn't be available? Is there, I mean, at the end of the day, would there be anything different that a jury could do?
A jury could give punitive damages in a common law tort claim, but here this court has said that punitive damages are not available for constitutional torts. Jason chose to bring this claim that limits the damages, and I disagree with what the state said. I think Jason is in a situation where its damages are nothing here.
Response to the state's argument that constitutional claims can be satisfied, a sufficient remedy can be provided without damages if sufficient procedure is provided.
I disagree with the state saying that the criminal procedures or the appellate procedures in the prior civil case are an adequate remedy. And I think this case shines a light on exactly why that can't be so. If a law enforcement officer is allowed to ignore actual confessions and statements from witnesses who heard specifics that tie in with the crime scene, if they're allowed to sweep that under the rug and not only allow and push a civil proceeding against the person they think committed a crime, but push a criminal proceeding, the process that is allowed or that supposedly protected Jason was entirely controlled by Agent Ludwig. He wrote the arrest warrant affidavit. He's the one that testified at the probable cause hearing at preliminary. No one was able to show that he was lying or what evidence he had that actually disproved his statements until the discovery was given months and months later.
With what we said in the Carter civil case on appeal, that, that Officer Ludwig did actually investigate other leads.
Well, two things, Your Honor, Justice Oxley. First of all, we're here at a motion to dismiss stage. And since
This is a kind of a unique situation where, given the entire history of this case.
situation, and as we've pled, there were leads coming in that were reviewed, and then very shortly after, Agent Ludwig said, stop investigating those people. So was there initial consideration? Perhaps. But within a mere months, as we have pled, Agent Ludwig focused on Jason, and even though confessions and specific facts and other evidence that obliterated any probable cause, as well as any even reasonable reliance on his feeling that Jason committed this crime, 4 years later, he's still banging the same drum when he had evidence within his possession that were that was just completely contrary. So, and I would also point out, Justice, yes, Your Honor.
To the state's argument regarding Wagner and footnote 6 and how that relates to sovereign immunity. As I read Wagner, it was once a Godfrey claim has been established by looking at whether or not there's an adequate remedy, then the functional equivalent analysis in 669 doesn't matter. And the state's position is no, it's actually much more limited than that. Can you respond to the state's argument?
I disagree with the state. If we have established a constitutional tort, if we have determined that there's not an adequate remedy and have shown that we get this tort, we're limited in our damages that we can ask for. But the functional equivalency test no longer applies. That's why this court set forth the all due care constitutional immunity that has to be pled and proven. I see I'm out of time. I'm so sorry. May I have just a brief moment to sum up? Thank you, Your Honors. The state is asking this court to say law enforcement can do whatever they want in investigating a crime. Is that the law that should be here in Iowa? Is that the answer when people ask what rights or what liberties we prize and what rights we maintain? I ask this court to reverse the dismissal, follow the precedent in Baldwin and Binkus and Lynette, and let this case proceed to investigation, and perhaps we'll see you again at summary judgment, but the dismissal was incorrect. We ask for reversal. Thank you.
By adjourned after the submission of Carter versus State of Iowa et al. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.